Mr. Johnson,
very
can I please ask you a question? Because you said something I want to follow up on. You said when they posted the notice, you called your stepdaughter, correct?
Yeah.
That's what you just said. And you said to her, what's going on? And she said that the defendant gave her the check, right?
I asked her was the rent paid or not.
And what did she say?
She said no.
Why did she say no?
Because the problem is her and her daughter.
I don't want to hear about that. Did Mr. Bunn give her the money order you gave him? Is that what she said?
That's what she said.
Okay, because that's my view, that it's the daughter that's the problem here. He's saying nothing because he knows better than to say anything.
But why did he lie to me in the first place then?
What do you mean lie to you? How did he lie to you?
He said that he was going to take the rent over to the office.
Well, he didn't. According to your daughter, he gave it to her. I'm going to ask you this question. Did you give the rent check to his daughter?
No, I never got a rent check.
Let me ask you, where is the office that this might? I feel like the office is in Canada.
Where
is the office?
It's in Compton.
Compton,
We stay in Paramount.
Not on the premises?
No.
That's why you were not paying the rent, the two of you, because you had to get to a location.
Yes.
That's why I was asking you before.
Yes.
Did you have any other issues with rent? Because how do we know that the rent check you were handing your stepdaughter was actually getting to the landlord? It's the daughter who's the real culprit here in some way. Then we are going to excuse the three of you while we deliberate in this matter.
This courtroom is now in recess.
I don't know about the two of you, but there is no way that I could come up with any legally principled basis in which to rule in the plaintiff's favor.
I'm with you right there. That's the only thing I understood today.
Right? They seem like folks who are down on their luck, but it's their job to convince us by a preponderance of the evidence that they gave this money to the defendant. And I'm absolutely not convinced about that. They were confused about so many things. They were confused about when they talked to Nita, where Nita was. At one point, Mr. Johnson said she was on the phone and she was in the parking lot. There's way too much confusion.
See, that's
there.
what I wanted to pick up on. He did say she was in the parking lot that day, but then he said she was on the phone, so I thought, well, maybe he was confused. He said when he met Mr. Bunn in the parking lot, she was there because she was moving.
Did he say that in his oral testimony?
Yes, because she was moving to Las Vegas. Then somehow he moved along, and then at some point he said he spoke to her. So I kind of didn't go back to it, but I absolutely heard the same thing, and that's why I'm sufficiently confused at the end to not give him a penny.
Not only that, he says here that Ricky turned in the rent for us a few times with no issues.
And he never did. He never did. He said it.
No,
that's why I went
that's
through
right.
each month I went through. So
it sounds like we're unanimous. in
Yeah, we're
dismissing.
unanimous.
I think they failed to meet the burden of proof.
Yeah, that's
Very
it.
good. We've reached a verdict, and it's unanimous. Mr. Johnson and Ms. Foray, you remember at the beginning of the case, I said that court decisions follow a certain formula. When you are suing somebody, you've got the burden of proving by a preponderance of the evidence, that means more than 50%, that your claim is true. And when it's unresolved, when we're unsure, that means you haven't met your burden. I mean, you certainly heard me give Mr. Bunn a little bit of a hard time about not being able to provide evidence of where he was. The reality is he doesn't have to do that until you meet your burden. Until you've established the elements of your claim, the defendant can just say nothing.
Okay.
So, unfortunately, you haven't done that. We don't know if people are being intentionally deceptive. There's no evidence of that. We don't know if it's just confusion or a miscommunication. Ms. Foray, your daughter's a material witness for both of you. It would have been helpful to have her here. But in the absence of that, this was your burden. And unfortunately, you didn't carry it. Mr. Bunn, there's no evidence that you stole anything. We're not sure what happened, and that means that we have to dismiss this case. But really, we do wish all of you the best of luck.